There is breaking news tonight on a massive Toyota recall involving defective airbags. It covers 2.9 million vehicles in the U.S.
Toyota has reached a settlement in a class action lawsuit regarding defective airbags, amounting to $78.5 million. The plaintiffs assert that this settlement would effectively address all claims and disputes related to economic losses that have been raised against the company. The complaint asserts that specific airbag control units, ACUs, and their constituent parts manufactured by Toyota are deemed defective due to their susceptibility to an electrical overstress condition. The plaintiffs assert that there is a potential defect in various Toyota models, specifically the 2011 to 2019 Corolla, 2011 to 2013 Corolla Matrix, 2012 to 2018 Avalon, 2013 to 2018 Avalon HV, 2012 to 2019 Tacoma, 2012 to 2017 Tundra, and 2012 to 2017 Sequoia. This alleged defect has the potential to cause the passenger safety system to malfunction, leading to the failure of airbags to properly deploy in the event of a collision. The complaint involves two suppliers involved in the production or distribution of ACUs and/or components for the cars, along with other automakers including Hyundai, Hyundai Mobis, Kia, Honda, Fiat Chrysler, and Mitsubishi, which are all named as defendants in the litigation. There is no indication of the submission of settlement agreements or any other agreement documents to the court involving any of the remaining defendants. The plaintiffs assert claims of RICO breaches, consumer protection legislation violations, fraud, unjust enrichment, and breach of warranty. According to their assertion, a significant number of consumers have reported instances of airbag failure in the vehicles implicated in the class action, namely in the context of severe crashes. According to the lawsuit, the defendants discontinued the utilization of the recalled ASIC in approximately 2019. The ASIC is a constituent of the reportedly faulty air conditioning unit, ACU. The plaintiffs assert that the abandoning of the ASIC provides evidence supporting the fault in the ACU. Toyota has reached an agreement to pay a sum of $65 million in order to resolve the lawsuit, with the exclusion of preliminary notice and settlement administration expenses. The original equipment manufacturer, OEM, has also consented to prolong the warranty coverage for new parts of class members to a duration of 12 years, commencing from the day when the court grants approval for the settlement conditions. The warranty would encompass the expenses associated with repairs, replacements, parts, and labor that are directly linked to the recall. Excluded from the extended warranty coverage are automobiles that are inoperable or possess titles indicating salvage, rebuilding, or flood damage. Furthermore, Toyota has committed to allocating a maximum amount of $3.5 million towards the establishment and management of an outreach initiative aimed at enhancing the rates of recall remedy completion. Toyota drivers who wish to obtain a recall repair or replacement subsequent to the effective date of the settlement, pending approval by the judge, and are not furnished with a loaner vehicle, will be entitled to payment from the settlement fund. According to the proposed settlement deal, Toyota is slated to get a credit of $10 million, which would be allocated towards future loaner vehicles and outreach projects. Individuals who require repair or replacement services pertaining to the purportedly faulty airbag module in a vehicle that has not yet been subject to a recall have the option to request a courtesy loaner vehicle or file a claim for reimbursement of rental car expenses from the settlement fund within the designated claims period. According to the terms outlined in the settlement agreement, a maximum payment of $250 per class member will be disbursed unless both parties reach a mutual consensus to establish a higher limit and then propose the increased sum to the settlement special administrator for official endorsement. In May 2022, a consolidated lawsuit was initiated by 53 plaintiffs hailing from 23 different states. This legal action followed the original filing of a multi-district litigation in 2019, which subsequently led to the court partially granting Toyota's petition to dismiss in 2021. The automobiles were acquired in the states of California, Florida, Nevada, Texas, South Carolina, and Washington. Toyota originally attempted to seek the dismissal of the lawsuit. Although Toyota has consented to the conditions of the settlement, its final approval is contingent upon the evaluation and endorsement of Judge John A. Kronstadt in the U.S. District Court for the Central District of California. The hearing pertaining to the settlement agreement has been scheduled for November 16th. In the event of approval, The lawsuit would be dismissed with prejudice, so precluding the possibility of initiating a subsequent legal action pertaining to the same matters. The agreement stipulates that Toyota will reach a settlement without acknowledging any culpability or wrongdoing, with the intention of avoiding the burdensome, costly, risky, and uncertain nature of ongoing litigation concerning the claims. According to the complaint, by the year 2015, a number of individuals had already suffered fatalities or injuries due to the ACU fault. The ACUs were also subject to an investigation initiated by the National Highway Traffic Safety Administration, NHTSA. According to a timeline of study conducted by the National Highway Traffic Safety Administration, NHTSA, numerous defendants expressed a need for an analysis of the airbag control units, ACUs, subsequent to instances when airbags did not properly deploy. In April 2019, the National Highway Traffic Safety Administration, NHTSA, announced its decision to broaden its inquiry to encompass Tier 1 suppliers, manufacturers, and a total of 12.3 million cars. Just prior to the expansion of the inquiry, the National Highway Traffic Safety Administration, NHTSA, reported that it had uncovered 2 significant frontal crashes involving Toyota vehicles, resulting in 1 fatality. According to the National Highway Traffic Safety Administration, NHTSA, the accidents in question occurred between a 2018 model year Corolla and a 2019 Corolla. These vehicles were equipped with an ACU, airbag control unit, that included enhanced levels of ASIC, application-specific integrated circuit, protection. Moreover, it was observed that both ACUs exhibited non-communicative behavior, indicating that the ACU could not be accessed using an event data recorder, which is a phenomenon observed in similar instances of EOS involving other original equipment manufacturers, OEMs. There have been no more instances of EOS occurrences reported for any other Toyota products, including Corolla models equipped with the ACU system since the 2011 model year. Similarly, there have been no reported EOS events for Honda and Mitsubishi vehicles that utilize the ACU system. The defendants in the lawsuit are being accused of engaging in the act of providing deceptive statements to the National Highway Traffic Safety Administration, NHTSA, with the intention of concealing and minimizing the claimed fault. According to the lawsuit, the recalls in question fail to effectively address the ACU defect, since the proposed remedies do not entail the removal and replacement of the defective DS84 ASIC, which is identified as the underlying cause of the ACU defect. Every defendant involved in this action has been aware of the ACU defect for many years, as evidenced by internal testing and numerous incidents of airbag and seatbelt failures resulting from crashes. Nevertheless, they persisted in promoting and selling the FLAD class vehicles, ACUs, and ASICs to the market. According to the plaintiffs, Toyota, Fiat Chrysler, Hyundai, and Kia USA have acknowledged the presence of a problem in the ACU, which has been installed in over 5 million vehicles of the specific models mentioned in the lawsuit. Approximately 1,426,000 vehicles from the model years 2010 to 2014, including the Chrysler 200, Chrysler Sebring, Dodge Avenger, Jeep Compass, Jeep Patriot, and Dodge Caliber, were affected by the recall. Likewise, around 1.1 million Hyundai Sonatas and Hyundai Sonata hybrid vehicles from the years 2011 to 2013 were included in the recall. Furthermore, approximately 508,000 Kia Forte, Kia Optima Hybrid, Kia Forte Coupe, Kia Optima, and Kia Sedona vehicles from the years 2010 to 2013 were affected. Lastly, nearly 2.9 million Toyota models were also subject to the recall. According to the complaint, it is anticipated that there are approximately 10 to 15 million vehicles that possess the problematic ACU and ASIC component, although have not undergone a recall. Individuals who possess, lease, or have previously possessed or leased any of the vehicles subject to recall as of July 31, 2023, are deemed eligible for inclusion in the class. Individuals desiring to verify whether their automobile is included in the class action lawsuit can utilize a Vehicle Identification Number (VIN) lookup tool accessible on the settlement website. Having said that, do you think Toyota is still a reliable car company? Share your thoughts in the comment box below. And if you've watched up to this point, thank you so much. For more videos about EVs, Toyota, Tesla, Ford, and the most recent auto news, please consider subscribing to Tech Addicts.